Well, hello, and welcome to another Sunday morning coffee with Dr. Childress here. So, today I want to be discussing New York's Kyra's law. Everybody's coming out with their child named laws here. This is New York's version of Kayden's law, which all the states are passing. New York's done some very interesting things and some variations on it. So that I'm not going to be addressing the overall cadence law, but just more specific parts of it. Particularly what I want to focus on relative to their Kyra's law, New York's Kyra's law, is the child attorney part. They have a statute where they, in any custody conflict where they're worried about anything, they're going to be appointing a child's attorney. Now, that can go either very, very good or very, very bad, depending upon what the task of that child's attorney is and what that role is. And so that's what I'm going to be discussing today. But then there's some other variations or things in Kyra's law that are intriguing, that are of interest. So I thought I would address those as well today. Um, so let's see. So yeah, while I'm going to focus or I'm going to discuss other aspects, really this is discussing the role of the child's attorney in the family courts, and so this is broader than just Kyra's law, but they in New York are doing it apparently consistently. They'll be appointing an attorney. Now, what Kyra's law says. So it starts off by saying, short title, known as Kyra's law. Let me just say something about that for a second. We should not be putting children out in front. Okay, that's the role reversal thing where you put it's the child who says, and it's the child who, we shouldn't be doing that. If you have a child protection law, put a child protection law, but don't be putting the child out front because that puts anybody who argues against it as if we're arguing against Kyra and the safety of children. No, we're not. And so I'll put Eric, Rod McCall, and for the love of Eric, I'll put up Eric as our poster child for our position, but I don't like doing that. Okay, we should not be putting the children out front. We are all protecting all children from all forms of child abuse. So that I want to say that right off the front on Kayden's law and Kyra's law and Ohm's law and everybody else's law. We shouldn't be doing that. We shouldn't be putting the children out and making our argument for us. So anyway, it says Kyra's law, subdivision 1 of section 240 of domestic violence relation law is amended by adding a new opening paragraph to read as follows. The legislature recognizes that the safety of children is of paramount importance and is an integral element of their best interests. To that end, the legislature finds that judicial decisions regarding custody of and access to children must ensure children's safety as a threshold issue. That is huge, okay, because that seemingly requires that in all cases of child custody, we get a proper risk assessment for possible child abuse to the appropriate differential diagnoses for each parent. The only thing that causes severe attachment pathology is child abuse because the attachment system is a motivational system. Motivational systems always have direction. That's what makes them a motivational system and not a regulatory system that goes up and down. So motivational systems for pleasure, pain, eating, sex, and attachment all have a direction to them. To create a different direction, the direction for the attachment system that rejects a parent is leading to predation and death and starvation. So that's the direction of death. So the direction of the attachment system is always towards bonding. If you have a child rejecting a parent, the only thing that causes that is abusive range parenting somehow to change that direction of the motivation. So it's either from the targeted parent or it's psychological abuse by the lied parent. That's the only thing that's going to cause it. So if it's a threshold issue, and if it's paramount in importance, and if this is the only thing that causes severe attachment pathology, then in all cases of court-involved custody conflict involving severe attachment pathology displayed by the child, a child rejecting a parent, a proper risk assessment needs to be conducted to the appropriate differential diagnoses for each parent, because child safety is paramount and child safety is a threshold issue. So let's get a proper assessment out of all these cases. So another interesting issue, Kyra's law spends a lot of time, let me pull it back. Kyra's law spends a lot of time talking about domestic violence issues. And that's Kayden's law. Kayden's law is focused on the domestic violence aspect of things and then kind of tosses a child abuse kind of in there. But Kyra's law does a much better job of handling the domestic violence issues. And so that's what I just want to note here. If anybody's authentically worried about domestic violence issues in the family courts, look to New York's Kyra's law for how they address it. They define domestic violence well. Okay, the things they're talking about on domestic violence are things we are concerned about. Okay, I would prefer they use intimate partner violence rather than domestic violence, because intimate partner violence has more grounded in the research, has better definitions to it. But we can do that when it comes up over to the mental health people. So the court's worried about domestic violence, has its definitions of what it's worried about. And I think they're solid definitions in New York. And then when it comes over to the mental health field, we'll translate domestic violence into intimate partner violence, and we'll provide the court with information relative to its concerns on that. Yeah. And so for legitimate concerns, there's legitimate concerns on both sides for spousal abuse and for child abuse. So, we need a proper risk assessment to both sides of that possibility. Now, what Kyra's law says about domestic violence here. So, where either party to an action concerning custody of or a right to visitation with a child alleges in a sworn petition or complaint or sworn answer, cross petition, counterclaim, or other sworn responsive pleading. Okay, so that's a low threshold, that if either party makes an allegation in any sort of sworn statement that the other party has committed an act of domestic violence, intimate partner violence. So the targeted parent, I'm going to pull this back up again, I want to be clear on this. The targeted parent is making an allegation of spousal abuse, domestic violence, psychological spousal abuse by the allied parent using the child as a spousal abuse weapon. Okay, so I want to be clear on that to everybody involved. The targeted parent is making a spousal abuse allegation against the allied parent using the child as the weapon. Now, for our culture, we will be able to see that a little bit better with the narcissistic dad variant, where we have a normal range mom, and that has a higher spousal abuse feel to it of using the child as a weapon. So that'll be a little bit more clear to everybody. However, the other variant also represents spousal abuse using the child as a weapon. That's the borderline mom variant, and that's the normal range dad, and that's going to have higher false allegations and higher anxiety associated with it. That too is using the child as a weapon of spousal abuse and psychological abuse. So I want everybody to be really clear on that the targeted parent will meet that threshold. So all of the applicable stuff that New York's law, Kyra's law, is talking about since that threshold will be applicable for the targeted parent in this situation. So that the other party has committed an act of domestic violence, and such allegations are proven by a preponderance of evidence. So that's what we're going to the issue, and that's going to be the mental health report that's going to be able to answer that. The court must consider the effects of such domestic violence on the best interests of the child, together with such other facts and circumstances as the court deems relevant. So it's all the issues related to the shared persecutory delusion, factitious disorder. All of that information is relevant to the best interests of the child here, based on the targeted parent's allegation of spousal abuse. Deems relevant in making a direction pursuant to this section, and state on the record how such findings, facts, and circumstances were factored into the direction. So everybody may initially start with the idea that the domestic violence is coming from the targeted parent and they're the dangerous human, but there's allegations of domestic violence by both litigants, by both parties. And so they need to be properly addressed, properly evaluated, and accurately diagnosed. When child abuse is a considered diagnosis, our diagnosis has to be accurate 100% of the time, because misdiagnosing child abuse is too devastating to the child. So we can do that. We can get an accurate diagnosis 100% of the time when we're motivated to do that. But we can't be lazy. We just can't just jump at whatever it appears to be. We got to get a proper assessment on this stuff, because this is complex kind of across allegations, and we can't be making a mistake on it. So there's three types of dangerous pathology. These are a category of pathology in mental health called dangerousness: suicide, homicide, and abuse, child abuse, spousal abuse, and elder abuse. And I want everybody to be clear that there are concerns here with all cases of family court custody conflict and the child rejecting a parent, all cases, that we are concerned about possible DSM-5 diagnosis of 995.82, spouse or partner abuse psychological of the targeted parent by the allied parent using the child as a weapon. So I'll make that allegation for the targeted parents. They're focused on their kid. They're worried about the child abuse allegations. I'll make the allegation of spousal abuse using the child as a weapon, duty to protect. And in creating such in using the child as a spousal abuse weapon, the pathological parent creates such significant pathology in the child that it rises to the level of child psychological abuse. That's your shared persecutory delusion and false, factitious, artificially created attachment pathology. So in just the child rejecting a parent, that symptom alone, because the only differential is child abuse one way or the other, should activate all professional duty to protect obligations. Just that symptom. And so all the forensic psychologists with their custody evaluations for 40 years have been failing in their duty to protect because they have not been conducting a proper risk assessment for the child abuse that's involved one way or the other. And they should have been returning a child abuse diagnosis. They haven't been. They've lulled everybody to sleep about what the pathology is. And we need to wake up and start taking affirmative and proactive steps to protect children from child abuse. Kyra's law. If an allegation that a child is abused is supported by the preponderance of evidence, that's going to be our mental health assessment, risk assessment for the child abuse, then the court shall consider such evidence of abuse in determining the visitation arrangement that is in the best interest of the child, and the court shall not place the child in the custody of a parent who presents a substantial risk of harm to that child, and shall state on the record how such findings were factored into the determination. So from the targeted parent's perspective, that's going to be getting the child psychological abuse diagnosis. So we need to get this out to a risk assessment, proper risk assessment, and get an accurate diagnosis of the delusional thought disorder and the factitious disorder that's in play, and get the child abuse diagnosis. Once we have that from the mental health people, that's the preponderance of evidence from a diagnosis. The diagnosis is going to be disputed because this is custody conflict and litigation. The appellate system for a disputed diagnosis is second opinion. So let's get a second opinion, third opinion if we need it, 2 consultants and 1 person do it. whatever we need to do on the mental health side to get an accurate diagnosis coming back that the court can then rely on regarding child abuse, because the court's going to be making its decisions. And if we send a kid to an abusive parent, we'll destroy that child's life. So the court has to rely on the mental health diagnosis coming back, which means the mental health people have to get an accurate diagnosis 100% of the time. So we get a person do it. Let's get a second opinion. Let's get a third opinion. Let's do what we need to do. Let's document the symptoms. Let's get a good, high quality mental health assessment for child abuse, so that the court can make its decisions and we can take the proper steps regarding these families in this situation. So, and the court shall not place the parent or the child in the custody of a parent who presents a risk. And so if that's child psychological abuse, if I've got a narcissistic borderline parent who's a little off kilter and using the child as a weapon, that's a risk to the child. And so we're not. That's where potentially, where is it? Here it is. The continued visitation schedule is. Okay, that's your compromise solution to a lot of the fighting that's taking place. But we'll get there. As soon as people are motivated to do the right, protect children, we can start protecting children. So the differential diagnosis in all cases of severe attachment pathology, child rejecting a parent, is the targeted parent abusing the child in some way, thereby creating the child's attachment pathology towards that parent? Or is the allied parent psychologically abusing the child by creating a shared induced persecutory delusion and false factitious attachment pathology in the child for secondary gain to the parent of manipulating the court's decisions on child custody? So there it is. There's your question. We need an answer to that question. We need an accurate answer to that question. New York's Kyra's law. The court shall state on the record and in writing any finding or credible allegations of child abuse. Well, it's got to consider the allegations that are being made by the targeted parent. Is the court in a position of expertise and knowledge to be able to make diagnoses of child psychological abuse and delusional thought disorders and factitious? No. That's not that the courts are not trained in making diagnoses of factitious disorders as opposed to the real disorders, or delusional thought disorders as opposed to reality. It needs to get out to a proper mental health assessment. Now, the problem is the mental health people in forensic psychology aren't competent in that either. Okay, so you might as well get it out to your car mechanic, or pick somebody, somebody off the street, and present the evidence and ask them for a diagnosis. The mental health system is substantially failing the family courts, the parents, and the children. And so we need to get appropriate seriousness in our mental health people to the diagnosis that we're involved in. There's no place for lazy in the family courts. There's no place for ignorance in the family courts. You need to know what you're doing, and you need to put in the effort to know what you're doing, so that we get an accurate diagnosis 100% of the time. So, and the court has to address that in its findings, and so it's going to have to say how it used any reports, any mental health reports coming in, and those sorts of things. And so DSM-5 diagnosis of child psychological abuse made by a licensed mental health professional is that report that the court should be getting. And we get a second opinion on it. We just do what we need to do. So from me, Dr. Childress, I will make what I believe is a credible allegation of risk, that the allied parent is psychologically abusing the child by creating a shared induced persecutory delusion and false factitious attachment pathology in the child for secondary gain to the pathological parent, of manipulating the court's decisions regarding child custody, and to meet that parent's own emotional and psychological needs. So there's your credible allegation. So what are you going to do about it? Let's get a proper assessment on it and figure it out so we can make decisions about the child. Now, here's some interesting little points I just want to point out. Such direction may provide for reasonable visitation rights to the maternal and or paternal grandparents of any child of the parties. That is excellent. Okay, I think that just a little sentence like that acknowledges the grandparent rights. And I think that's such an important issue in the family courts. It gets lost in the parental conflict that's going on. But we have a whole level of grandparents who are also in grief, who are also available, loving supports for these families and for these children in helping stabilize them. But they cut off entire families with this pathology. And so recognizing the importance of grandparents and the role of grandparents' rights is important. And I think New York got it just right. And I don't think it needs a big issue. And, maybe grandparents' rights can argue on this. I think just that sentence will allow us to then open up the discussion and get the appropriate treatments in place. The other interesting thing is friendly parent. They have this term they used, friendly parent, and they defined it in their definition section. And I go, oh, geez, are we going back to favored parent? When I first got here, that's what pathological, narcissistic, borderline, dark personality was being called the favored parent. And I said, no. So I shifted that over and start calling them the allied parent out of family systems word, which is more neutral. And I went, oh, geez, we're going back to this friendly parenting. But look how they define it. Friendly parent means the actions of a parent or legal guardian that support a child's contact and relationship with the other parent or legal guardian. That's excellent. That's excellent. That's entirely consistent with what we got here. Okay. That if you're teaching your child appropriate, proper values, then you're teaching your child to get along, to solve things, to fix things in relationships. Okay. So you're supporting the other parent's relationship with the child and the child's ability to be loved by a parent. That's a friendly parent. Yeah. And so I thought that was excellent. Now, let's talk about these attorneys. Now, the issue for Kyra's law is going to be whether this is, they are appointing a minors counsel representing the expressed voice of the child, or whether they are appointing an amicus attorney who is representing the court's interests in the child's effective treatment. I'll explain that. So here's Kyra's law. In any proceeding under Article 6 of this Act, the court shall appoint an attorney to represent the child when credible allegations of serious risk to the child's safety have been made. So that's, again, kind of a pretty low bar. Okay, credible allegations to the child's risk, they're going to put an attorney on that situation. Now, with the pathology we're worried about, the child's psychological abuse, shared delusion, psychological control of the child, that child's expressed voice is a manipulated voice. It's being psychologically controlled by the pathological parent. That's the exact pathology we're worried about, a shared persecutory delusion, creating a false, factitious pathology. And so the child's voice is a symptom of the pathology. Or it could be an authentic voice. That's a factitious disorder or a real disorder. We don't know whether it's a real voice or a factitious voice. We need to get it out to the mental health people to get an assessment on that. Minors counsel or an attorney should not be making a diagnosis of whether that's a real attachment disorder or a factitious disorder imposed on another. That's not the role of an attorney. That's a role of a doctor. So the attorney's role representing their client should be to make sure that the client child has a proper risk assessment for the appropriate differential diagnoses of concern, and that we get an effective treatment plan for that diagnosis. The attorney's role should not be to make the diagnosis. Okay, so that's the important role differential in the role. What we currently have are minors counsels who just represent the voice of their child. So the voice of the child, they just come in and whatever the child wants, that's what they're representing because that's what they think their role is. But when they do that, they've misdiagnosed the child abuse. And so A minor's counsel who is representing the expressed voice of the child is appointing an attorney representing the child abuse. Okay, because essentially we have a ventriloquist puppet, and if you're representing the voice of the puppet, you're representing the voice of the pathological parent who's controlling the puppet. So you are advocating to the court that they continue the psychological child abuse, which is really problematic if you're an officer of the court. So minors counsels, and this is really, I've worked with multiple minors counsels, and I will say this with certainty. Minors counsels are colluding child abusers when they represent the expressed voice of the child. I've worked with maybe one or two who have understood their larger responsibilities, but for the most part, minors counsels, I would say, are colluding child abusers in the family courts. And that's a legal system problem you guys got to get a handle on, that you have attorneys who are leading the court into being the judges are also child abusers because they're following the advice of their child abusing attorneys. If you're going to appoint a minor's counsel to represent the voice of the child, then appoint an attorney to represent the treatment. So now we'll have 4 attorneys, one for the mom, one for the dad, one for the pathology, and one for the treatment. That's stupid. Get rid of that role. Okay. Now, what we do need, though, is that's a recognized role. We need somebody neutral in the middle here that's helping to navigate neutrality relative to the courts. So you guys have tried minors counsels, which are over-empowering the child. Bad thing, bad, destroys therapy. Absolutely destroy. You put a minors counsel on that represents the child, therapy stops forever. And I'll tell you why later if you want, but that's a bad thing. They tried guardians ad litem. A little bit better because guardians ad litem represent the best interests of the child, not the expressed voice. That's the difference. Minors counsel represent the expressed voice. They should be representing the best interest. The guardians ad litem represent the best interest, but now they're making diagnoses rather than getting it out to their job would be to get it out to the proper assessment so we can get an accurate diagnosis, and they're not supposed to be making the diagnosis. But the reason they are is because the mental health people aren't. We got awful mental health people. That's just forensic psychology. We get them out, get diagnoses in, and then we can fix them. The legal system. Parenting coordinators. Sometimes you guys appoint parenting coordinators trying to fill that middle role. No, they don't know what they're doing either. And so that's a bad role. Here's what we need to do. Okay, so here's a solution for that. It's to appoint an amicus attorney. Now, this was first suggested to me by an attorney in San Antonio. And I was working with this attorney, and she says, I'm going to ask the court for an amicus attorney. And I said, what's that? And she says, that's an attorney to represent the court's interests in the situation. And I go, that's exactly right. That's exactly the role we need. We need an attorney representing the court's interests in getting an accurate diagnosis and effective treatment plan. We don't need to over-empower the child by giving a 10-year-old child an attorney. You know, the 10-year-old child doesn't need an attorney. You know, you got mom and dad, we got enough things, and he needs to be a 10-year-old child. But we are worried about the child's well-being. And the court has a legitimate interest in being worried about the child's well-being. You know, it's before the court, we got child abuse. And so how does the court address its legitimate interest in the child? By an amicus attorney representing the court's interest in exactly that thing. Okay, don't try to find somebody to empower the child. No, let's appoint an attorney for the task we need solved. The court needs to know that we're getting an accurate diagnosis and effective treatment plan. So I would consider, if we're developing a pilot program, I'm going to consider that amicus attorney as part of the treatment team. Okay, so we have the treating family therapist, we have the amicus attorney, that's part of the treatment team. We may get other people involved on the treatment team as well, but at least that's the core of it. And what I call that is a key, because it looks like a key. So we have the court at the top who appoints an amicus attorney who then works with the therapist as a part of the treatment team. And notice a directional line here is the authorities coming from the top. We're not over empowering the child where the authorities coming up from the child's authority, where he gets the attorney to argue against the father, and then no, you shouldn't have an attorney arguing against the parent, that the bedtime needs to be, extended by half an hour or something. And so what we do then is we take this key, court amicus attorney therapist, and we insert it into the family conflict. Boop. And so you got the therapist right in the middle of that spousal conflict there, and you got the child and the therapist working with the child, and the amicus attorney is there understanding what's happening. If you need court orders, if you're doing a contingent visitation schedule, and you got the therapist who's running and balance, absolutely get an amicus attorney sitting on that, so the therapist can say, I'm extending the dad's visitation for 3 days because the child didn't have a successful week. The amicus attorney goes, okay, get it. Send me over the data. You send them over the Excel file. They see the data. If there's any problem with it, the amicus attorney can go to the court. Court wants to know anything going on, the court can ask the amicus attorney. So this is the solution right there. You're looking at it. And so what New York has done in appointing the attorney in all cases is a good thing if it's going for this model. If it's doing the old model of a minors counsel that overempowers a child, so now you have the child's attorney is arguing for extended bedtimes with the mother and something, like, no, the children do not need attorneys. What we're worried about, absolutely, the court has a legitimate interest in the child's well-being. Let's get an attorney on that to make sure everything happens. But let's get the attorney working with the therapist. And if the therapist isn't doing a good job, let's get the therapist out of there. If they're not, if we're not getting a good treatment, you should see treatment progress on this type of pathology within 3 to 6 months. I would hope to get a resolution on stuff within 6 months. Okay, less than that, hopefully. So if we got an incompetent therapist, let's move them aside and get a competent therapist. Now, what will happen, what I recommend happen off of this, is the court develop a pool of these amicus attorneys who know what the pathology is and can work with the therapist, and a pool of therapists who know what the pathology is and can make the diagnosis. And then we get this knowledge base in the professionals that the parents and families can just come into, an established knowledge base that the court and everybody knows what to do. So New York is absolutely on the proper path. And when I saw the New York Blue Ribbon Commission on forensic custody evaluations, absolutely correct. Get rid of the forensic people, get clinical back. This is a delicate role, but I think it's a good role. We can get rid of the parenting coordinators, get rid of the guardians ad litem. This is the role we need. So relative to that, my suggestion is to New York State Legislature should fund a pilot program for the family courts with university involvement. You've got great universities there, so get some university involvement for the evaluation research to develop the diagnostic assessment and treatment protocols for the differential diagnoses of concern surrounding court-involved custody conflicts. So just take it to the next step, put together sort of a structured pilot program that we can get all these answers. And I would recommend what I'm seeing. I'd recommend maybe a New England kind of thing, because you got Massachusetts, you got New York, Pennsylvania, Ohio, and you can do a regional kind of thing. Pick a couple of universities, pilot program for the family courts in that domain. I don't know. Legislature, fund some stuff and give your university researchers the mandate to solve the problem. And guess what? Your universities can solve the problem. If you give them the proper mandate, they can come up with the diagnostic assessment and treatment protocols and the legal arguments to support those. And we can solve all the professional fighting around the family courts. So with that, I'll say goodbye for this Sunday coffee talk. And we'll address something else about the family courts next week. So we'll talk to you then. Bye-bye, everybody.